My Lords, I appear in this matter with my learned friend Ms. Hewling McCarthy in the so-called trade appeal. My learned friends Mr. Gammy, Mr. Pillai and Ms. Murray appear on behalf of Her Majesty's Revenue Customs. Can I begin by apologising for the inconvenience that I understand the court has been put to?
Well, don't worry about that. It's only fair to you to say that although we had a preliminary view as to how matters should proceed, you had given the court your proposals. And what we were going to propose is this, that it would be unfair for us to start with the appeal, which is what we had intended, and then move on to the application with appeal to follow if permission is given, because you both expected to proceed the other way round and had told us that, told the court that. So how we propose to proceed, if this is acceptable to both of you and there's no good reason to object to it, is this, that you have half an hour to persuade us to grant permission to appeal. We will then consider whether to grant permission. If we grant permission, then we'll go on with the appeal, and clearly the appeal will last at least the day. And then we can go on to the appeal, which has already been the subject of permission, tomorrow. If, on the other hand, we refuse permission for the appeal that you're going to ask for, then we would obviously finish this well within the morning, and we would propose that the appeal, which has been granted permission, should start at 2 o'clock this afternoon.
My Lord, yes.
Thank you. Well, I think the right thing to do is, we have read the judgment, we have read the proposed written cases on the proposed appeal, and I think the right form is for you to have half an hour to persuade us to grant permission. If we grant permission, then obviously what you've said in that half hour will be part of your oral case in due course. If we refuse permission, then we go away and come back at 2 o'clock.
My Lords, with that in mind, can I propose to do this? I'll start with identifying the question that lies at the heart of the proposed appeal, which I say is fundamentally a basic question of statutory construction, a question of fundamental importance to the tax system, one to which there is not any answer in the case law to be found, and one upon which the back of the answer to a number of subsisting appeals rest.
Can I just interrupt you, just so nobody's under any illusion? It may be that when you've had your half hour, we'll want to hear briefly from Mr. Gammy on the permission to appeal, in which case you obviously have the right to come back, but just so you know, that's one possibility.
I'm very, very grateful.
Sorry, thank you. Yes, you say this is a point of fundamental importance on which many prospective and future appeals will hang.
And I'll come on to that, but what I want to do is identify why I say it's a point of basic statutory construction. We know what the basic facts are. Yes. We know that Eclipse acquired rights from Disney by license in, and then disposed by license out of those exact same rights to the distributor. They did so in interdependent transactions, which took place over a time unit measured only on atomic clocks, a legal fiction, if you like.
Yes.
One for horologists rather than lawyers. The transactions were not shams, and they could have delivered an economic profit. The rights were real rights, finding of the first tier, and you can't ignore the transactions so as to treat merely cash as passing. And again, that's a finding of the first tier. Now, we can talk about those transactions as preordained, we can talk about them as interdependent, we can talk about them as composite. Those are all labels that you might use to describe the effect, the legal effect, of the factual picture. And I will use them interchangeably, but they don't advance our understanding of the legal consequence of that factual state of affairs. Because the question is, what is the nature of the factual inquiry mandated by the word trade when the first tier is confronted by interdependent transactions? Or, putting it more crisply, what does it mean in the context of trade to view the transactions realistically. And I stress in the context of trade, because as the Supreme Court has very recently identified in the Deutsche Bank and UBS appeals,
Yes.
the exercise of viewing facts realistically is an exercise that is not amenable of a single answer for all of the tax code. If you're asking the question, do these transactions give rise to a trade, the factual inquiry is different to if you're asking a different statutory question not before the Supreme Court or prospectively before the Supreme Court, such as did Eclipse acquire a series of payments. And the question, again, is, does the word trade require that you look at the overall outcome of a series of commercially linked transactions? that language, overall outcome, I take from paragraph 38 of Deutsche Bank. Does it require that you view these transactions as the purchase of an income stream from a synthetic entity comprised of the Disney Group? I don't take any point about synthetic entity. It may be that properly understood, viewing the facts realistically requires that you treat the vendor to Eclipse and the purchaser from Eclipse as a single economic entity. That is a possible outcome of the answer to the factual inquiry mandated by the question trade. We know lots and lots about what a trade is. There are lots of cases on badges of trade and so on. Yeah. And if we know the answer to the question of statutory interpretation that I've posed, then applying those cases to this fact scenario and arriving at an answer is, I say, a relatively straightforward exercise. If we're applying them to the overall economic effect of the transactions entered into by Eclipse, such that it purchased a couple of income streams, one fixed and one contingent, then the answer is that the transaction is not a trade on these facts. If, on the other hand, we are applying those badges to a transaction which is properly understood as a matter of statutory construction, a purchase by license in and a sale by license out, then you get to a much more interesting and live question, a live factual inquiry about whether these transactions and this state of affairs amounts to a trade. So fundamentally, that is the issue, and there is no guidance on it in any of the case law. And at paragraph 20 of my written case, I set out a whole series of transactions, all entered into on day one, all involving the purchase by individuals in the form of a partnership of income streams, if you're allowed to look at the overall economic effect of the transactions. And those transactions all take place on day one.
Sorry, which paragraph? I beg your pardon.
Paragraph 20
Thank you
of
so
the
much.
written case on page 79.
Yes. Thank you so much.
So all of those transactions, enzyme tankers, halcyon,
yes.
all of those transactions are they all ought to have the same answer, because they're all interdependent transactions involving a question of trade or no, where the prospective trader starts off with an amount of cash on day one, and at the end of day one, or that tick of the atomic clock later, has either a fixed income stream or a contingent income stream or a combination of fixed and contingent. So if you're allowed to look at overall economic effect, then the answer to all of those cases should be the same, because they're all purchasers of income streams, and in none of those cases is there any active exploitation by the putative trader following the tick of the atomic clock. But what instead we have is a whole variety of different answers. In some, the first-tier tribunal has answered the question, you have to look at them separately. In others, the first-tier tribunal has decided you have to look at them together. In some, the revenue haven't taken the point. And this is a point of importance, obviously, both to the Jones point and the trade point. That's not what justice looks like.
If you're right, would not the Court of Appeal's decision give future guidance? Well, if you're right that these are all the same cases on the facts.
The Court of Appeal doesn't analyse the question either. What the Court of Appeal says is the overall economic effect of these transactions is the purchase of two income streams. But it doesn't ask the prior question whether that is the nature of the factual inquiry mandated by the question of statutory construction, what is a trade?
Implicitly, it must be doing so.
Well, implicitly, it is arriving at it is assuming the answer. It doesn't ask the question of itself, and it assumes an answer which is different to the answer that the first-tier tribunal gave, because the first-tier tribunal rejected Milan and Friend's submission that that was the appropriate thing to do, and that's at paragraphs 360 to 365 of the first-tier tribunal decision.
What do you say in response to the respondent's answer at paragraph 29 of their printed case?
Well, that's the point that I've already addressed, being that if we know what the answer is to the factual, the extent of the factual inquiry, in other words, if we know whether when confronted with interdependent transactions that are said to be trading, we look at them separately or we look at them together, then what Milan and Friend says at 29 is right. There is a whole long, rich history of trade, and if we treat these transactions separately, if given permission, I will say, they look like trading transactions. There's a purchase and then there's a sale. If, on the other hand, we look at them together as a purchase of an income stream, I've already said that there isn't here a trade. But none of those cases deal with the predicate being, is that the right way? Or how do you answer that factual inquiry? Does the question trade require that you look at overall economic effect? Is that what the statutory draftsman has addressed our attention to, or has he or she addressed our attention to a different question, which is what's the nature of the activity? Of course, I'll go on to say, if given permission, that trade is really about activity. It's not about the effect of an activity. So I say that although my learned friend is right to say there's a lot of case law on trade, there's no case law on this point. And this underlines all of the cases in paragraph 20 of my written case.
You are suggesting that nature of activity and overall economic effect are two different boxes, mutually exclusive.
For the purposes of trade, I say one is the right way to answer the question and one is the wrong way. One is the right and one is the wrong factual inquiry.
They're not the overall economic effect when the activities all occur within a very short space of time. Be a relevant factor in looking at the nature of the activity?
It might be. So it does not follow from the fact that you disaggregate, if I can put it in that way, the license in and the license out, that the transaction is necessarily trading. There will be some circumstances where a license in and a license out, or a license back, will not be trading transactions. So it does not follow from the fact that you disaggregate those two limbs that necessarily you have a trade.
Isn't that the problem, in a way, that your argument highlights, that point highlights, that because the circumstances of each case will vary, and the precise nature of the arrangement, which will be driven at least in part by a desire to navigate through tax legislation to avoid tax perfectly properly as a matter of law, that the factors will vary, and small differences may make all the difference in the result. And if one tries to be too analytical about it and too precise about what is the actual test, you'll merely be creating new problems from the ones which you fairly identify exist at the moment.
Well, I say that's a problem I'd like to have, and it's a problem it's important that I have, because one of the questions that you need to know the answer to in weighing up all the factors is, what is the transaction that I am weighing up? Am I weighing up the overall economic effect, in which case all of those cases in para 20 are all day one cases with nothing happening afterwards? Or am I entitled to take into account and consider the legal consequence of the fact that there are essentially here two limbs? There are lots of important consequences in this case arising from the fact that there are two limbs. So,
But is it such a stark distinction? I mean, you can lease something and sublease it, or license it in and license it out on a basis which doesn't have to be disregarded. The lease or the license in and out are perfectly realistic and valid transactions, but there is no, it's all prearranged, there's no customer, there's no risk, and you wouldn't call it anything other than an investment.
well, you're, with respect, begging the question that I'm inviting you to answer.
Good. Well, I just wondered, though, whether merely recognising the validity of the licence in and licence out and accepting that was, as I thought you were suggesting, really a decisive point.
No, it's not a decisive point.
No, so it's not.
Because you have to have, you have to, once you know what it is that you're analysing, i.e. either an income stream or a purchase in and a purchase and a licence, then you're entitled to, and indeed must, have regard to all of the surrounding circumstances. Now, I not for a second do I accept that this is a transaction without speculation. Not for a second do I accept that this is a transaction without a customer. First Tier has erred in relation to, and materially, in relation to both of those points. But at the moment, I'm trying to identify for the Supreme Court the point that I say is of general public importance and is very arguable. The problem is, if you send me away without permission, then cases like Mr. de Gorse's case, which the Court of Appeal has suspended a hearing of pending the outcome of this appeal, are going to, the Court of Appeal is going to be left scratching its head. It's going to have to answer this question itself.
Where's that case?
That is at paragraph 20 of...
de Gorse 5, yes, 20 subparagraph 5, yes.
So,
Was the way you're putting it to us this morning put to the Court of Appeal?
yes. No, well, it wasn't put to the Court of Appeal. It was put to the upper tribunal.
Was it put to the Court of Appeal?
But we're not yet... it's in the application for permission to the Court of Appeal.
Yes, I see.
But isn't the trouble, I mean, you're criticising the present Court of Appeal for having effectively decided this was an income stream, which is the same which is consistent with the position in the divorce case, isn't it? So what needs...
It is, but
I mean, if that's clear enough, why do we need to clarify it further?
well, it's clear what they've done.
Yeah.
It's not clear why they've done it.
Can I just make sure I've understood your answer? This point wasn't argued in this case in the Court of Appeal, but it's going to be argued in the divorce case. Is that right?
It was, I think, my lord, that is fair. It was not at the forefront of my then leader's submissions.
Well, I'm not asking whether it was in the forefront. I was asking whether it was argued.
It was in the skeleton. It was not pursued in oral submissions. This way of putting it was not pursued in oral submissions.
It might be said that even if you get over all other hurdles, that it would be better for us to decide it after the Court of Appeal has expressed a view, rather than to do it without the benefit of the Court of Appeal's view. It is almost a leapfrog appeal on this point, isn't it?
My lord, I hear that point, but I would say it would be better still if your lordships were of that view to remit the matter to the upper tribunal, because this is plainly a Jones case. I say that actually it is a short point of statutory construction. It is a matter for your lordships to express a view on. It is a point of general public importance. There are the sorts of consistency issues raised. The upper tribunal misunderstood the nature of its jurisdiction. So if you're not minded to decide it yourself, and I can, I hear the sense of your lordship's submission, your lordship's answer. I beg your pardon. You no longer have to make submissions. That's from me.
Never had it quite put like that, but thank you. A new experience, yeah.
New experience in as well. But the point is, if you wait for the Court of Appeal, you are inviting the wrong tribunal to do it. The right tribunal is the upper tribunal.
But the Court of Appeal is going to do it, aren't they, if we don't grant permission to you?
Well, can I... yes, but that does not do justice to my client in this case. And in the annual report of Her Majesty's Revenue and Customs, the Revenue identify this as a leading case. They say that £635 million rests on it. It's the only case mentioned in the annual report of HMRC. So for you to say that the Court of Appeal in divorce may address it is absolutely true. But to that I have two responses. Firstly, it does not do justice to my clients. And in this case, a very, very important case involving an awful lot of money. And secondly, it does not put the question before the right tribunal.
Well, you can also say, can't you, that you're all here ready to argue the point and the time's been set aside by the court.
Well, if the
perhaps that's a submission you might accept.
Resources is also a relevant factor, then yes, I rely on that point as well. We are all here. You may have other more interesting things to do, but here we are. I'm not sure there's anything else I need to say by way of permission. I do stress the point that I've touched upon, that the best way, unless you're persuaded that this is a trading case, for this case to be resolved in a way that does justice to the parties, given the amount of money at stake, is for the matter to be remitted to the upper tribunal so that it can exercise its specialist expertise in relation to a question of fundamental importance and where there are conflicting decisions at first instance and a deficit of legal content.
Can you just highlight the points which you would then say the upper tribunal would have to reconsider or depart from, take a different view on, i.e. the key points of either law or perhaps analysis? Is that possible to do by looking at the...
Well, I can do it by reference to the decision.
Yes.
I'd rather do it by reference to submission, and I can show you the decision as well if you'd like.
Yes.
Put another way, how can you reduce your central proposition to one of law?
Well, if I'm in a typical Edwards and Bairstow world, then obviously ex hypothesi, I don't need to rely on Jones. I win, or well, in that world I win. If there is no legal content, no error of principle involved at first-tier tribunal level, then I'm also outside Jones. But what I've attempted to do in my written case is formulate a proposition that articulates why it is that the upper tribunal has been given by the TCEA the jurisdiction it has been given.
Yes.
And then I go on to explain why it is that this case satisfies that jurisdiction. To answer Lord Toulson's question, what the upper tribunal does is it examines Jones. It says, I say wrongly, that this is not a Jones case because there's no question of principle, because we all know what trade means. It then says, so this appeal has the shape and character of a traditional appeal, i.e. we're in the Edwards and Bairstow world, and in the Edwards and Bairstow world it's all a matter of evaluative assessment. And given that it's a matter of evaluative assessment, it's all for the first-tier tribunal, and so it's not appropriate for it to do anything other than decide that the appeal is an appeal that fails because it doesn't identify an error of law.
So we're going to just say very briefly.
Yes, let me just find the upper tribunal decision. It's in Core Volume 2, at page 167. And the passage dealing with Jones begins at paragraph 38 on page 186. The upper tribunal then comprised Mr. Justice Sales. The heart of his reasoning is perhaps at paragraph 46. Where he says, in fact, the question whether an activity should be classified as being in the nature of trade is, in my view, a very poor candidate for a more adventurous and expensive approach to treating it as a question of law now to be adopted. And he says the relevant evaluative classification assessment has been firmly established for a long time. And I agree with respect with his second sentence, but it does not address the point that I've been saying at the prior point, which is, well, what is it? What is the transaction that you are seeking to analyse? Is it the purchase of an income stream, or is it buy and sell? The answer to which must be all the same for all the cases. So he then goes on to say, at paragraph 48, it therefore transpires that the appeal has a traditional shape, and the arguments on each side were very much in the standard form. And he then says, evaluative assessment, and not for me. And I say, fundamentally, that his error is in failing to identify the fact that this is a classic Jones case, because there are it's a very important question, there are lots of conflicting decisions, there is a deficit of legal content. What's happening is that all of these first-tier tribunal cases are going up the appellate chain, and appellate judges are shrugging their shoulders and saying, and that doesn't deliver justice, it doesn't deliver consistency to any of the appellants in any of those cases.
What about the fact that the Court of Appeal appear to have taken the view, say they took the view, that not merely this was, as it were, Edwards and Bairstow unappealable, but they would have reached the same view?
Well, the Court of Appeal assumes the answer to the question that I've been saying is the key question. You can see that at 118 and following.
Thank you.
And it misapprehends what Mr. Aronson submitted. Mr. Aronson did not accept, contrary to what the Court of Appeal says, that it was appropriate to describe the AODs as an investment type activity, or the generation through the license in and license out of the AODs as an investment type activity. So the Court of Appeal wrongly understands Mr. Aronson to suggest that. And you can see that at the end of
123.
So that's I'm afraid that is an error of the Court of Appeals. But it describes so it says at 123, stripping the business down to its essential elements, the transactions on which Eclipse 35 was engaged had two aspects.
Yes.
One aspect, and then it identifies the fixed income stream and the contingent income stream.
Yes.
But that is an answer to a question of statutory construction that it has not posed to itself. In other words, there must be a right and invariant answer to the question, does the factual inquiry mandated by the question trade or no involve an assessment of the activity that the taxpayer has entered into, or an assessment of the overall economic effect of that activity? Now, the consequence of that answer, trade or no, will not always be the same.
No.
But there must be an invariant answer to that question. And at the moment, all of the first-tier tribunals and the upper tribunals after them are all treating the answer as variant.
Yes, I see.
So that's fundamentally, I say, the problem here.
Is paragraph 141 of the Court of Appeal's judgment not their statement of what the correct approach is? They say that assessing the reality of the transaction requires a detailed factual investigation of what happened and what the taxpayer actually did. That seems to be your request, that for an examination of the nature of the transaction.
Well, that's the analysis that has to be done once you have answered the question of statutory interpretation. Do you look at overall economic effect?
I'm not sure. That seems to me to be... Is it yes, I see. It's not looking at whether it's a sham or not.
The transactions are accepted not to be shams.
So he looks first of all at Snook and says, we're not in Snook. What we're dealing with is what's the reality of the transaction. And he says, to assess the reality of the transaction, you've got to have a detailed factual investigation of what actually happened and what the taxpayer actually did. To my mind, that seems to contradict the view that the Court of Appeal has left open, a view that all you need to look at is the general, the general economic effect. I mean, in a sense, they are giving the answer that you are asking this court to allow the appeal to proceed to find the answer.
But they're giving that answer against a background of having misunderstood Mr. Aronson's submission before them. They're saying you have to look at the overall economic effect of a transaction which comprises the purchase of income streams. And I've already accepted, and I accept again, that if this transaction is characterised properly as the purchase of income streams, from the perspective of the question of statutory interpretation, trade or no, then we are not trading, and neither are any of the other cases in paragraph 20. Can I just
Yes.
give you paragraph 95
Of the Court of Appeal?
Of Deutsche Bank.
Of Deutsche Bank.
I'll just read you the first sentence of that
Yeah, okay.
paragraph.
Fine.
It's at tab 28. I don't think you need to turn it up.
Yep.
This point illustrates the need to apply the Ramsey approach with sensitivity to the particular fiscal consequence which is relevant. In other words, as I said a few minutes ago, what viewing a transaction realistically means
Yep.
is contingent on the statutory context in which you are conducting that exercise. And that's absolutely vital to appreciate, because you can't view the transactions realistically for all purposes, because that's an approach that ignores the fact that what you are doing is an exercise of asking, as it was put in Mawson, what facts answer to the statutory description. Viewing the facts realistically is an exercise that you have to do by reference to the nature of the question that the statutory draftsman has posed to you. And what the Court of Appeal is doing in the passage that my Lord Hodge directed me to a second ago, which I've now lost, is it's conducting a general exercise of viewing the facts realistically. It's not asking the prior question, what does trade mean? Sorry, my Lord.
141 is the paragraph.
141.
Yes.
Yes, Lord, I have it. So it's assuming, Court of Appeal is there assuming that you can answer the question, what actually happened? What is the reality of this?
Yep.
Without knowing the nature of the factual inquiry mandated by the statute and the statutory question, trade or no.
Yes.
Well, is that fair? I mean, the next 2 paragraphs later, they are dealing with Mr. Aronson's argument about what one would expect to see in trading transactions.
Yes.
To say that the Court of Appeal was trying to identify the nature of the transaction without regard to the specific statutory context seems a bit difficult, because, I mean, what part of the nature of the transaction were they looking at, unless to ask whether or not this was in context a trade?
Well, as I said earlier, once you have identified the statutory question and you understand the factual inquiry that question mandates, you then have to have regard to all of the features of the transaction.
Yes.
And it is relatively uncontroversial what the case law tells you to do once you know whether what you are analysing is the purchase of an income stream or a licence in and licence out. There's no difficulty once you get to that stage.
The trouble with that is you're just substituting a different question of categorisation for the basic question of categorisation. You're saying that what is a trade is to be ascertained or to answered by deciding what is an income stream, or, on the other hand, what is a licence in and a licence out. But I don't see why one should substitute those prior questions, or why they shouldn't be simply, why one's impression as to the answer to them might not be simply a guide, or one of the guides to whether this is a trade.
Well, can I answer that question?
I mean, it's a bit of both, isn't it? This could be regarded as both as a licence in and a licence out, but a licence in and a licence out, which was particularly interesting because the two were back to back, and they were going to secure effectively the same sort of result economically as you would get if you put money in a bank.
Well, I don't accept that. I don't accept that is true. But can I deal with the prior question? If you look at divorce in the court, in the upper tribunal, it might just be worth turning that up. And I'll just need to find where it is in the authorities bundle. I think it's in volume 2.
Yep. It's volume 2, tab 30, yep.
Volume 2, Very
Or is that first tier, and then
so
the
it's at 31.
upper
in the
tribunal is the upper tier? Yeah, yeah.
Can I just invite you to look at
Where?
paragraphs 96 and 97?
Yep.
Sorry, wait a minute, where do we find the clause?
So
Authorities
it's in
2, tab 31.
Thanks, yeah, got it.
95, 96 or 96?
96, 97. in
Righto,
particular.
yep.
And can I just invite your lordships to read those paragraphs?
Yeah.
So, what the upper tribunal, and this was a point that was addressed in great detail by me to the upper tribunal in
Yeah.
this case, what the upper tribunal is saying in 97 is once you analyse this transaction as the purchase of an income stream, nothing else matters because the purchase of an income stream isn't a trading transaction. And that's the problem. Once you assume the answer to the statutory question being what factual inquiry does trade mandate, you assume that the answer is it mandates an analysis of the overall economic effect. Nothing else matters.
What
because
happened-
the purchase of an income stream.
It's not just the economic effect, is it? That is how they have characterised this particular transaction. And it's substantially the same as what the Court of Appeal did in this case. Unless you're submitting that the economic effect is in principle irrelevant to the characterisation of the transaction, which I don't think, in the light of your exchange with Lord Toulson, you are.
No, I'm not. But if you pose two questions. Question one, are you trading? Question two, have you purchased an income stream? If the statutory question is, have you purchased an income stream, then the factual inquiry is of one sort. If the question is, are you trading, I will say, if given permission, that the factual inquiry is of a very different type. And what the upper tribunal is doing in paragraph 97 is assuming that the answer to that question is you view the facts realistically, you don't need to ask yourself the question, what factual inquiry does the statute mandate? And once you've viewed the facts realistically and concluded that what you've done is purchase an income stream, nothing else matters. Nothing else matters. And that is true not merely of Mr. de Gorse's case, it's also true of every single case at paragraph 20 of my written case, including Ensign Tankers, in which the House of Lords held that it was a trade and analysed the transaction as involving the production and exploitation of rights. So Ensign Tankers was a day one case. Perhaps it would be helpful to turn up Ensign Tankers.
Well, actually, you're way past your half hour. I know you've had some questions, but can you keep it pretty short from now on, please?
Let me take you to Ensign Tankers.
Well, very briefly,
And then
yes.
I'm in your lordship's hands.
Well,
And Ensign Tankers,
Volume 1, tab 20.
great.
Can I just very briefly say, does it matter whether it's categorised as an income stream or as simply as a non-trading business? What matters, from your point of view, is that it's not a trade.
Yes. I'm only concerned with whether it's a trade. And the facts in Ensign Tankers were that members of a partnership wanted some capital allowances. They entered into an admitted tax avoidance scheme that required that they be a member of a partnership and that partnership be trading. On day one, and you can pick it up here at page 661 internal 1231 bundle page, right at the end of H, the
1231.
scheme was
Sorry, which one?
1231 bundle page. Find the sentence that begins at the right at the end of that page. The scheme was a single composite transaction embodied in 17 documents, all of which are dated 14th of July 1980. And included in those documents was a production agreement, which was just an agreement that the members signed, and a distribution agreement. So the production agreement you see at D on 1232. So they, in effect, the partnership just pays over the money. And then you see the distribution agreement between B and C at 1233. So they grant a license in perpetuity and throughout the world, the right to exploit the films. You then turn to 1235.
Could you give me the internal page number from the report, please?
665. 1230.
So I'm now moving on to 665 of the
Yep.
report.
Yep.
The bundle page is 1235.
Yep.
Well, unfortunately, my bundle's different in that number. So, okay, 6.
And it's in tab 21.
Yep.
The Leonard.
Yeah, I'm sorry.
So at D, the parties agree that the 17
Yes.
documents, and you have that.
Yep.
And then if you go on to see how how Lord Templeman characterises it, you can see at report page 671 at B, the financial consequences of the scheme, namely the expenditure by Victory Partnership of £3.25 million on the making of a film, produced the corresponding physical consequence of a first-year allowance of that sum.
Yes.
And then if you go to 675, report page,
Yep.
the same is said again at C. So, and then finally at 677, between D and F, Lord Templeman says the production and exploitation of a film is a trading activity.
Now, the Court of Appeal cited that. Are you, at this point, repeating the submission of Mr. Aronson in the Court of Appeal, which the Court of Appeal addressed at paragraph 148 and following, or making a different point?
I need to know what it was that Mr. Aronson said at 148.
Acquisition of a license to the rights and sub-licensing with a view of profit constitutes inherently and as a matter of law carrying on a trade.
Well, that's my Edwards and Bairstow point.
But the upper tribunal in De Gorse considered the engine tankers and distinguished it in paragraph 99, didn't they, on page 21 of their decision, and
Yes.
page 1369.
As the court did in this case.
Exactly.
Court in this case said, look, there were features in Ensign which made it right to conclude that that was a trade. Those features don't exist in this case. That doesn't mean that there might not be other features in this case which did make it a trade. It meant that Ensign was of no help to you.
But the difference that is identified in De Gorse
Yes.
and in this case by the upper tribunal is that De Gorse is said to involve a production and disposal, whereas this case involves an acquisition and disposal. But in the High Court in Ensign Tankers, Millett says obiter that both the production and the acquisition of a film and its disposal are trading transactions. He says that obiter because, of course, he's only confronted.
Well, they make the point in De Gorse, again, if it's relevant, that Ensign Tankers did not merely buy and immediately dispose of rights, but contributed to the financing of the production of the films as one of the members of the partnership.
But that's a statement of I don't understand the principled distinction. I genuinely don't understand the principled basis for distinguishing Ensign Tankers from this case, because in both Ensign Tankers and this case, you have a series of day one transactions at the start of which the putative taxpayer has a lump sum, and at the end of which he has either a fixed or contingent or both incomes. And there is no conceptual basis that I can see for distinguishing Ensign Tankers and this case.
Very well.
And I don't, with respect, well, my submission is that the fact that one involves a production and the other involves an acquisition is not a basis of principle. They both can be characterised as the purchase of an income stream, if it is right so to characterise them, but the House of Lords in Ensign Tankers said it was not. Or at least didn't say it was not.
It was more than the purchase of an income stream, because it was the purchase of an income stream plus.
Quite. That's the point.
The purchase of an income stream
Plus.
Ours is.
It wasn't, no, in Ensign, it wasn't only the purchase of an income stream. It was also the investment in the actual production of the film.
And ours is not only the purchase of an income stream, ours is the acquisition of film rights. That's what the First Tier Tribunal found. So either is capable if the correct approach to the question of statutory construction is that you have to recognise that the limbs are disaggregated, because with trade, you're trying to understand the nature of the activity. Either is capable of being a trading activity. There's no difference of principle between a production and disposal for an income stream on day one, or the acquisition and disposal for an income stream on day one. As a matter of principle, they're identical.
Very well. Thank you very much.
I'm grateful.
Mr. Gammy, perhaps 5 minutes just so we can have the revenue's position on this before we consider whether to grant permission. I mean, if there's nothing you want to say, I don't say there's anything you should say, but if there's anything you want to say.
No, indeed, my Lord. May I just deal with Ensign and take you to tab 20
yes, of course.
In the first volume of authorities.
This is Mr. Justice Millett's decision.
And this is Mr. Justice Millett's decision.
Which page, internal numbering?
And if you look at the internal page of the report, 765, you'll see a paragraph beginning just above F, where he says, with respect to the commissioners, none of these features throw any light on the question they were called to decide. Thus, Victory Partnership's inactivity after the 14th of July 1980, that's the date when all the documents were signed, was the result of the arrangements it made on that date. It acquired and paid for a partially completed film, engaged the services of LPI to complete the film on its behalf, undertook to deliver the completed film to LD2, and entered into agreements with LD2 and Firrily for the commercial distribution and exploitation of the film. And that, I say, was the creation of an income stream plus quite a lot, in fact. My Lord, if you buy a copyright or intellectual property, piece of intellectual property, and you license it, you may be investing, you may be trading, and that is the evaluative judgment that the first-tier tribunal, when these issues arise, has to address its mind to, and in this particular case, that is what the first-tier tribunal did, and the upper tribunal and the Court of Appeal found that it had made no error in its approach to that question, applying the standard tests of trading in Ransom and Higgs and the test in Edwards and Bairstow to support its conclusion that this was not trading but was investment and effectively income derived from a business related to the exploitation of films. In relation to what my learned friend says about the Jones point, I don't understand what the error of law is, which would give the upper tribunal jurisdiction to do more than what it did in this particular case. The learned judge in the upper tribunal, Justice Sales, addressed all of this in the paragraphs to which my learned friend took you, on paragraphs 46 and 47 in particular, where at the beginning of paragraph 46, he noted that when pressed by me to formulate with precision what additional point of principle should qualify as a question of law beyond what was decided by the House of Lords in Edwards and Bairstow, Mr. Morne did not provide any satisfactory answer, and I would say the same remains true. And indeed, in paragraph 47, where he refers to the various cases on which Mr. Morne had relied, he said, in any event, Mr. Morne did not take me to the various cases to try to show how they might support his submissions, and indeed I would say the same is true here. My learned friend has taken you to de Gorse and has referred to a number of the other decisions. Those decisions are decisions in which, as we say in paragraph 29 of our written case, the tribunals and the courts have applied the standard principles to determine whether or not the taxpayer in question was carrying on a trade or otherwise, and those remain the tests that should be applied and that were applied in this particular case. My Lords, I would therefore ask you to refuse permission.
Thank you. Thank you very much, Mr. Gammy. Mr. Morne, anything you want to say in reply?
You've had enough of me.
We'll adjourn now and consider whether we will grant permission to appeal on this issue or not. Court's now adjourned.